know the power of the dark side.
But you know, happiness can be found even in the darkest of time. If one only remembers to turn on the light.
The beacons have been city! The beacons are lit!
Night gathers, and now my watch begins. It shall not end until my death.
Remember it well, then. This night.
For in those memories, we live on.
Do not cite the deep magic to me, witch.
I was there when it was written.
Call the banners.
All of them are all.
They've all sworn to defend my father, have they not?
They have.
Now we see what the words are worth.
But take heart. Look around you. You're not in this fight alone. We face our enemy together. And together, we will defeat them.
By all that you hold dear on this good earth, I bid you stand! Men of the West!
How's everyone doing today? What we got? Okay, so 1 second. What am I trying to do? There we go. Ooh, why is my keyboard not working? There we go. How's everyone doing today? We got a couple people watching. So today we're gonna go over some Gina Carano stuff, some Donald Trump stuff, some tweet shit I saw the other day. There's one other thing. We're going to talk a little bit about House of the Dragon. We're getting real close. And, of course, what's it called? Some Rings of Power news that we've got today. So let me finish setting something up real quick. Forgot to do this earlier. Hang on. Second, almost done. Really should have done this earlier. Not a very good all stations start to tonight. What else am I thinking about? No, not for kids. Not what we want on here. Save, and we're back. Okay, what's up, Clifton? How you doing, man? I saw your post earlier on X. The quote from Trump, is that an actual, like, was that legitimate? That just seems so off base. Like, I can't imagine someone actually saying that in court. Actually, I take it back. I can't imagine someone's attorneys letting them say that in court. Okay. So we're going to start with this. I almost exited the stream. So I meant to do this a while back. If anyone remembers, I hopped over to Drunk 3PO's channel a couple weeks ago, about a month ago, actually, to talk about Disney's response to Gina Carano's lawsuit. And tonight, I'm going to go over her response to their motion to dismiss. So I'm going to share my screen here. What the? That's something under my desk. Weird. All right, let's look through this real quick. So let me kind of remind everyone where we're at with this. So we are in federal court on diversity jurisdiction. And what that means is that the parties on both sides of the V, see right here, the parties on both sides of that V right there are not in the same state. What that means, so Gina Carano is not living in California, and Walt Disney, Lucasfilm, and Huckleberry Industries are not, what's the word, at home in Montana, I believe she's in. Could be Wisconsin. I think it's Montana. So she sued, claiming all these different things, sexual discrimination, all this stuff. I thought you did. Didn't you share like this this quote from him about looking to see if he had enough money to say 2 more words? Or am I going crazy? I could be going crazy. It's been a long day at work, man. Wait and see what you say there. Let's see. Oh. Okay, I'm going crazy then, man. Motion to dismiss. Okay. Sorry, where's that? This is a great stream tonight, isn't it? Okay, let's go back to this. So, like I was saying, we're in federal court in California, sitting in diversity jurisdiction. Like I said earlier, that just means that the same state is not on both sides of the V, and that the damages sought are more than $75,000. So all it means we're not in federal court on a federal question. This isn't a national case. It's just because of where the parties live. That's it. Which is why, let me bring this a little closer and make sure my setting is correct. I don't want anyone to miss exactly what I'm saying here. Yep, I went down a little bit. There we go. Which is why we're using California law. I saw a bunch of people talking about this when it first came out, talking about how federal law doesn't allow this, and she's stupid for doing this, and Disney's going to win because of this. And they could be right, but it really doesn't fucking matter. Because at the end of the day, they don't use federal law in this case. The only federal stuff that will be used in this case is the federal rules of civil procedure. And it's because they are procedural issues. So, for instance, if when we get to trial, and you remember she demanded a jury trial, we get a trial and they are trying to decide how many jurors will sit in the box. That's a procedural question. So they'll use the federal rules of civil procedure to decide that. They won't use the California rules of civil procedure. They will use the California law to decide whether or not either party has reached their proof beyond a reasonable. No, it's not reasonable. What is it? It's more likely than not. I can't remember the exact wording, but in civil court, it's a lower threshold of evidence required. So let's go through this. We've got our beautiful table of authorities here. Okay, smart. You're using Boy Scouts. Trying to see if I know any of these off the top of my head. I knew one of them in Disney's thing. It was sadly it was a little exciting. It's like, hey, I knew that one. All right, let's look through this. After admitting that they discriminated against Carano for her personal political beliefs and subjected her to disparate treatment from her similarly situated male co-stars, the Walt Disney Company, Lucasfilm Limited, and Huckleberry Industries, collectively defendants, asserted that the First Amendment to the U.S. Constitution gives them absolute immunity. Defendants are incorrect. Neither the First Amendment nor the few cases applying the First Amendment to this context of casting gives employers the right to control or punish the personal speech of employees. None of Carano's comments reference defendants, Star Wars, or The Mandalorian, or had anything to do with defendants. Carano's claims do not seek to impose any message on defendants or to change defendants' speech in any fashion. See, if you remember, one of the cases that Disney cited was the gay club of Boston thing. It was about some parade that was going to take place in I think it was the late 90s. And their point was that the Supreme Court allowed the club or the parade organizers not to let the gay what's it called? Float. Yeah, we'll go with float. Not to let the gay float in the parade because it would obstruct the message that the parade was trying to do. Well, what they're saying here is that Carano's speech is not being. People are not seeing her speech as if Disney is saying that. So when she tweets, that big tweet that basically apparently compared the United States to 1939 Germany. No one is thinking Disney is saying that. Whereas in the parade, people would have a reasonable expectation to believe that the parade was sponsoring the Gay Pride Club of Boston or whatever it was called. So that's a dismissal on their first case that Disney cited, and they used that case quite a bit in their response. Carano's claims do not seek to impose any message or defendant or to change. Rather, Carano seeks relief for defendant's violation of laws of general applicability that do not, as applied here, inhibit or affect defendant's speech. Defendant's motion to dismiss, Doc 33, should be denied. As shown below, there are no facts in the complaint to suggest that Carano's claims implicate, let alone clearly establish, the First Amendment interest defendants assert. Defendants do not challenge the sufficiency of the allegations of the complaint to support the asserted violations of California law. And I talked about that a lot on Jay's stream. Disney writes this 48-page motion to dismiss, and they touch very little of the actual complaint. As her attorneys say right here, they don't really defend the fact that she's suing under California law. They don't sit there and say California law allows this and it doesn't. Her claim that we discriminated against her based on her gender is moot because of this. It just sits there and says we can do what we want because of First Amendment. You can't do that. You can't just sit there and argue the First Amendment covers me. I'll tell you what that reminds me of. It reminds me of when in Parks and Rec, when what's his name? When Ron Swanson is getting ready to do the barbecue at the park thing, and he hands the park guy a slip of paper that says, I can do what I want. That's basically what they're claiming the First Amendment is for Disney. Let's see. Legal standard. This is going to be fun. In deciding a motion to dismiss, I talked about this too. A court must accept as true the allegations of the complaint and must construe those allegations in the light most favorable to the non-moving party. Now, what that means is that when deciding the motion to dismiss, the court, in this case, it's the federal court for the Southern District of California, I think. Central District. So the Central District basically has to say Gina Carano's complaint is true. Now, if it's true, does this motion to dismiss defeat the truth? And usually things, you'd sit there and say, how do you get around that? Like if we're to assume that she's right or that the defendant is right, how do you ever win a motion to dismiss? And it's mostly just because usually when, at least in my experience, different readings, things like that, the reason that a motion to dismiss is successful is because the plaintiff has either failed to state a claim, they aren't a valid claimant yet, the thing that could lead to the lawsuit hasn't happened yet. That happens a lot in with like tax cases. If if the government passes a tax, but it's not applicable for like another 2 years, people will sue. It's like, well, you don't have standing yet because you haven't been harmed yet because the tax hasn't gone into effect yet. So you can file in 2 years if the tax goes into effect. So that kind of stuff. Let's see. When it comes to asserting an affirmative defense as grounds for dismissal under Rule 12b-6, as defendants do here, the Ninth Circuit has made it clear. And one of the reasons they're using the Ninth Circuit here is because California sits in the Ninth Circuit. Pardon my stroke. While Supreme Court precedent is the highest you can get, and you always want to use it, if you've got precedent from the circuit you're sitting in, it's always great to use. Rule 8 does not require plaintiffs to plead around affirmative defenses. And what that case is saying right there is that Gina Carano, in her complaint, doesn't have to say, this is why these 9 affirmative defenses do not defend against my allegation. You still have to prove that affirmative defense, or the defense has to prove that affirmative defense. Jeez. And ordinarily, affirmative defenses may not be raised on a motion to dismiss. Accordingly, an affirmative defense is grounds for dismissal at the pleading stage only if the plaintiff pleads itself out of court. That is, admits all the ingredients of an impenetrable defense. As explained in more detail below, that is obviously not true of the allegations below, or here, I should say. But first, it is necessary to address defendant's attempt to mischaracterize those allegations. I like this. This is going to be an important part of this. What's up, Breezy? How you doing, man? Kings. Love it. Oh, thanks, man. I usually wear a hat. I couldn't find my hat, one of my hats earlier today. So I was just like, you know what? Screw it. We're just going to let the hair flow. I'm kind of in my Beatles stage. But the motion then reaches outside the complaint. Wait, where was I? Defendants admit they terminated Carano for her personal speech, confirming that her pleaded claims are valid. But the motion then reaches outside the complaint while simultaneously misrepresenting Carano's comments in an attempt to justify her termination. For example, defendants represent that Carano's personal views conflict with Disney's values, motion 1, 2, and 5, while those of the other Disney employees referenced in the complaint apparently do not. Now, I wish I had both of these open, and I would if I could, but my screen's just not big enough right now. Where was I? Defendants then claim that Carano's comments would detract from defendants Disney's ability to convey its own chosen message. But there are no allegations in the complaint to support such a claim. The only claims set out on the face of the complaint are that defendants violated Carano's rights under California law. Facts defendants do not and cannot dispute at the stage of this case, which is true. Let's see. Oh, what's up, Maria? Maria, that's the second time you've left that. I don't understand the Marvel Jesus thing. Beatles stage is lit. I used to have hair down to my shoulders in my younger days. I was a skater boy. Oh my gosh. Story of my life. Now, oh, geez. Let's see. What was I going to say? Right. So, and this is the other issue I had with Disney's motion to dismiss. They were constantly addressing these phantom claims. They were sitting there saying, we have the right to do this because of this, this, and this. But this, and this were not part of the actual complaint at all. So it didn't make any sense. And what sucks even more is, think about it. You've got attorneys that were probably charging, $1,000 an hour to write this thing. And that's what you put out? Come on now. I saw Deadpool. Oh, you talking about the trailer for the new one? No, I haven't seen the trailer for the new Deadpool. Yeah, I did see I think I saw a clip of the trailer. I do remember something about Marvel Jesus in there. Yep. Okay, back to this. So the only claims set out on the face of the complaint are that, like I said, as to the specifics of Carano's complaint, and contrary to the defendant's assertion, Carano did not disparage anyone, and she certainly did not publicly trivialize the Holocaust, let alone grotesquely do so. Indeed, the Auschwitz Museum, and this is the big point on Carano's side, that the Auschwitz Museum made the same point as the one contained in Carano's post. Defendants claimed Carano's February 10th, 2021 post was comparing criticism of political conservative viewpoints to the Holocaust in Nazi Germany. But the point, which they quote, does not refer to conservative viewpoints at all. Likewise, Carano did not mock people who identify their pronouns to show support for transgender rights. And of course, several of the accounts that hounded Carano for not putting pronouns in her X header did not have pronouns. I do think it's funny that they call it X on here, while it was Twitter during all of this. So I think that's kind of funny. I probably would have left it as Twitter. John says, all this legal talk makes me that. I don't really know what to say to that. So the thing that I like about this, I really like this. So if you remember in the motion to dismiss, they used a lot of that tweet. The one that said, let me see if it's in this motion. Nope. Okay. So we all know what the tweet was. It was the one that basically said conservatives today are being treated like Jews were in 1939. Or at least that's the one that a lot of people thought it said. Hang on, chat. So the Disney uses that in their motion to dismiss quite a bit. But what's so damaging to their case on that is that, like it says here, the Auschwitz Museum posted the same thing. So are we going to say that, or are they, what they're basically saying is that the Auschwitz Museum was disparaging conservatives when they were doing nothing of the sort. So you can't have it both ways. You can't have Gina's tweet was tasteless and then say their tweet wasn't. It doesn't work like that. Maria, you said now with Elon Musk funding it. I don't know what that was in reference to, so I'm gonna keep going. If that was the money thing, it was. I was complaining about Disney's what's it called, motion to dismiss. Not these guys. I've thought these guys have been pretty damn spot on. I've been really impressed. Let's see. Put on their own. Yet, as set out in the complaint, defendants because they're. Oh yeah, I see. Yet, as set out in the complaint, defendants harass Carano over pronoun issues, enforcing their own view of orthodox speech outside the workplace. Indeed, as set out in the complaint, none of Carano's posts reference defendants, The Mandalorian, or any of the defendants' programs, and they have nothing to do with the defendant's speech. Because nothing in the complaint pleads that Carano's speech had any impact on defendants or their message, there is no basis on the face of the complaint to support the asserted First Amendment defense. Defense motion should therefore be denied. Again, I love that because, like I said, I said it on Jay's channel, and I said it here. Yes, Breezy. Yeah, I am an attorney. Yep. Gina filed a lawsuit claiming sexual discrimination. Basically, there's a little bit more and a little bit less, but that's the basics of what she claimed. Disney then filed a motion to dismiss said lawsuit and did not answer any of the complaint. They argued an affirmative defense, which you can't, like we saw earlier, in California, you cannot defend, you can't have an affirmative defense in a motion to dismiss. An affirmative defense requires that you affirmly prove it. You have to prove the defense. In order to prove the defense, the trier of fact has to hear both sides. So they shot themselves in the foot by trying to do that. They should have just answered the complaint. Yeah, Maria, I get that. What you need to remember, though, is they are not Elon Musk's attorneys. They are Gina Carano's attorneys. He may be footing the bill. X may be footing the bill, whichever one it is. But according to every single state's bar association, professional conduct rules, and the ABA conduct rules, they are her attorneys. And Elon may not even know anything going on in the case unless she tells him or she allows them to tell him, because it would break privilege. Even though he's paying for it, they're not his attorneys. And that is one of those things that you learn like day one of your PR class in law school. Because it can be a big deal in big litigation like this, obviously, because this would create conflicts. If they were also Elon's attorneys, then even though she's suing, who gets to decide if we're settling? If he gets to have a say at the table, then he gets to say, I get it, Maria. Then he would get to say whether or not they settle, and he's not part of the lawsuit. But you're right, Maria. That is probably why they called it X. I just think it's kind of funny. So this is the argument on why the motion to dismiss should be denied. So let's look through it. I'm not going to go through every little bit of it. I think some of y'all might like jump off a building if I tried to do that. But we're gonna try to, what's it called? In law school, we called it the honey test. And what that means is, and even I thought it was a little dated. The honey test is taking something like this and explaining to your honey so that she can understand, or he, I guess. But that's kind of what we're going to do here. But just not as I'm going to assume that y'all can understand at let's say 6th grade level. The core of defendant's argument is the legal proposition that under the First Amendment, an entity engaged in expressive communication may choose to exclude from its own communications other speakers who, in the expressive entity's view, would impair its ability to convey its own preferred message. Now, let's honey test that. If you're on a 3rd grade level, Breezy, I got nothing for you. But you can't enjoy Game of Thrones if you're on a 3rd grade level. So, well, let's honey test that. What that's saying is that crap, I gotta read it again. That a company engaged in expressive communication. Expressive communication would probably be defined as published works, books, magazines, TV shows, radio shows, things like of those natures, are allowed to deny other people the right to speak if they're speaking on that published work and their speech would affect the publisher's speech. Yet no court has held that media employers have an absolute right to exclude actors because of their viewpoints, religious, political, or otherwise. And that's going to be a big point there. Basically, what the purpose of that line right there is to say that, or at least to tell the judges in the Ninth Circuit, as much as you might agree with Disney, or if you don't like Gina, or if you don't like Elon, or if you love Disney or Bob, you cannot, as a matter of law, say that Disney's right about this. You have to, as a matter of law, you have to listen to the argument. That's what that line is in there for. Defendants do not accurately represent the work they cite. Indeed, in his okay, this is going to be a big deal. What they are saying is that Disney lied. They're basically about to tell the court that Disney lied to them. And if this is going to be big. Okay, let's see if I agree with them. Indeed, in his scholarly article, Professor, that's a name, Volok noted that while some assert the arguments defendants make here, the courts have not adopted those arguments. Some have argued that employers have a constitutional right to refuse to associate with people whose political beliefs they reject. But the Supreme Court has never extended the right not to associate that far. Volk, and that's his, book maybe, article. Let's see. Yes, we're going to open this, hopefully to the show. Let's see what this says. What? Okay. So this is weird. Okay, so they have cited this in a court. Hang on. Copies attached to Exhibit A. Okay, we're going down to look at Exhibit A. The exhibits might not be in here. Damn. So I am extremely annoyed at this because let's see if I can find it somewhere on the internet. So I wanted to see what this article said, like context and stuff like that. And I went to I found it weird. So I clicked that tiny URL and it sent me to a page that said, sorry, this article is no longer available. Which would be a pretty big deal if the website. The website's called Reason, Free Minds and Free Markets. If that website had decided to remove a document that a attorney was using, I think they'd get in trouble. Felicity, what's up? This case is interesting because this is being brought in California court, and they are notoriously liberal when it comes to workers. How unfortunate for Disney. That's it. That's what's so funny about this. They are Gina and Musk have sued them in California, which is their home court. I mean, Disney has a home court advantage in California, but what they've done is they've used the liberalness of the laws that Disney probably helped get written against them, and it's definitely interesting to see how this all plays out. And we're going to get to see this play out in about 2 weeks. I think the hearing on this motion is supposed to be like June 12th. That's a Wednesday. It probably isn't Wednesday. It's probably the 6th, 7th, or 10th, because they'll probably hear the motion on the 6th and then go into trial on the 10th, because they should all be ready for trial by now. Yep. So we're going to talk about how terrible light whips and things like that are, while talking about how trashed Bob Iger's getting in court. It's going to be fun. Let's see. So I found the article. So let me just Control F some of this into the article and see if I can find its. I hate when this happens. This is a quote. It should be taken straight from the article, but it's not coming up. Refuse to weird. Okay. We're going to skip that. And keep going. Sorry about that, guys. Let's see. Indeed, discrimination laws in place for decades limit private employers that create expressive content from discriminating against employees for their off-duty speech and their sex as alleged in the complaint. Defendants' motion to dismiss based on speaker's autonomy should be denied. Yeah, damn, I was really looking forward to going through that article. Let's see. Defendants do not have a First Amendment right to discriminate against Corona simply because they disagree with their speech. Defendants claim they have an absolute right to terminate Corona based. I can't read for shit tonight. Defendants claim they have an absolute right to terminate Carano under a concept they dub speaker's autonomy. Defendants rely on Hurley v. Irish. This is the case I was talking about. Hurley v. Irish American Gay, Lesbian, Bisexual Group, Boston. But Hurley does not help them there. And Hurley, the plaintiff, sought to march in the Boston St. Patrick's Day parade carrying its own banner, for that purpose of expressing pride in their Irish heritage as openly gay, lesbian, and bisexual individuals. It was this message that the parade organizers did not wish to express as part of the parade. The court noted that the parade organizers were only excluding a group from carrying its own banner in that parade, and that the organizers disclaim any intent to exclude homosexuals as such. And no individual member of GLIB claims to have been excluded from parading as a member of any group that the council has approved to march. As the court made clear, it was the attempted insertion of the plaintiff's message into the defendant's parade that was objectionable, a circumstance not present here. So, like I was saying, the whole thing about the Boston case, which is what we just talked about, is the fact that Glib was trying to just basically upstage the parade. They wanted to fly their own flag. And the parade didn't want a secondary message in their message. So that's why they told him no. And the court agreed. The court said, yeah, you have an absolute right to control your message. But what you don't have a right to do is control the message of another person outside of your message. For instance, in said parade, that Glib, the group that wanted to fly their own flag, could have gone outside and either had their own parade. They could have flown a flag outside the parade route, all that kind of stuff. But they just weren't allowed to go into the parade, join the parade, and then fly their own flag. And that's not what Gina did. Gina didn't go into Disney, walk around the parks, and say, hello? Anyone else just hear someone like yelling at me? That was a little creepy. What was I saying? Oh yeah, Gina didn't go into the parks, scream a message and then yell at Disney for getting angry at her for interrupting business. She took to her own personal Twitter account in the public forum, which thanks to Donald Trump, Twitter became part of the public forum prior to this case. Oh my God. I do live alone. I live 100% alone. So, where's my gun? I promise to turn the camera off before I have to shoot anybody. So I don't actually believe in ghosts, so that's not important. If you want to talk about ghosts, you can go over to Gatekeeper Stymio. They're talking about aliens right now. I think I finished the point I was trying to make there. Let's see. Laws of general applicability, including those that prohibit discrimination, apply to expressive employers. Ooh, this will be interesting. No, not really, Breezy. Rather than provide the blanket immunity, defendants claim generally applicable laws do not offend the First Amendment simply because their enforcement against the press has incidental effects on its ability to gather and report the news. Or, in this case, on defendants' ability to create entertainment. What's up? Remember that commercial? Remember? I remember. What's up? Yeah, I do. I think we are 100% alone. Let's see. The media, for instance, must obey the National Labor Relations Act, and publishers thus have no absolute and unrestricted freedom to employ and to discharge editors. Instead, the Supreme Court held that an anti-discrimination law in AP, that's the Associated Press, a prohibition on firing people based on union membership and union activities could constitutionally be applied to the media. What the hell is that? X-Wing, member for 3 months, says that. That's a grown man right there. He's a grown man. He's got a kid and everything. And that's what he did. You run your channel your way, and I'll run my channel my way. X-Wing, a member for 3 months, says penis. Better? Oh, what a silly goose. What are we going through? I got something for that. Hang on.
Wait, shut your mouth. Shut your mouth.
Shut for 1 second. Shut for 1 second.
Wait, shut your mouth. Shut your mouth.
What did
You're
you
just
just
coming
say?
off stupid.
You hear that? Let's see. Where were we? The business of the Associated Press is not immune from regulation because it's an agency of the press. The publisher of a newspaper has no special immunity from the application of general laws. He has no special privileges to invade the rights and liberties of others. Once again, meaning that just because you publish something, just because someone might say something in the thing that you publish that you don't agree with, doesn't mean that you have the right to go and remove their liberties to say it. Okay, let's skip through some of this. Hang on. Defendants are thus also mistaken in their view that under Hurley, the First Amendment embodies a core principle of speaker's autonomy that bars the state from dictating to expressive enterprises. So that's the craziest part of their motion to dismiss. That they were like, by the way, this thing 100% keeps you away from us. Like, what's the best way to piss off a judge? Tell him he can't do something. Like, that's the number one way to piss off judges. Judges have spent the last 250 years creating laws because an attorney told them they couldn't do something. Like, that blows my mind why you would tell a judge that. See, AP makes clear that expressive enterprises do not have complete autonomy to choose whom to hire, whether as editors, writers, or actors, and that they are not solely entitled to decide what association might impair their efforts. Now, what that means is, if we remember back to the complaint or the motion to dismiss, they're basically claiming that Gina's association, or the associating with Gina as she was, is damaging the brand. And what this is saying is, just because she has associations, okay, I can't do that. Just because there are associations that might impair your efforts doesn't mean that you have the right to fire her. They do not have carte blanche authority, for instance, to fire Jewish, Muslim, or Catholic writers based on their religious beliefs or expression, to fire union members based on their union association, or to fire actors based on their off-camera political expression. The applicable laws here are similar to those in AP. They merely forbid discharge for what has been found to be a real motive of the employer. X-Wing for $5 says, law boring, dance monkey. You know what? I'm going to give you one little thing for that. Nah, we'll be a little dice. I was going to burst out your eardrums, but my headphones are plugged in too, so I won't do that. Let's see. Under the allegations of the complaint, defendant's termination of Carano was not done for any First Amendment protected purpose. So this is going to be the crux of their decision here. To be sure, a visual medium relies on the physical appearance of the actors. This is why television and theater producers have the right to select actors based on race, color, or other aspects of appearance. That was the issue in Claybrook's v. American Broadcast. Let's see. Under the facts alleged in the complaint, nothing like that is at issue here. For example, in Claybrook's, the plaintiff claimed that the producer did not cast them because of their race in an effort to express a message that quote, only all white relationships are desirable and worthy of national attention. Accordingly, as the district court explained, the plaintiff's complaint explicitly takes issue with and seeks to alter the messaging of The Bachelor and The Bachelorette. Carano takes no issue with the defendant's messaging in The Mandalorian, nor under the complaint's allegation. Did her presence in the cast affect the program's message? So again, companies are allowed to hire so that, or visual companies, movie producers, Broadway, basically everything Disney does. Hang on a second there, Maria, because we do see 5 foot tall Wookiees. They're John Graber. But so what this is saying is that visual companies can discriminate so that the message of their visual thing works. For instance, a company producing Fiddler on the Roof would be allowed to discriminate based on race, so that the Russians look Russian. So that's what this is saying. Firing Gina Carano does not. Maria, I don't even want to know what your 666 rule is. Let's leave that to the imagination. Let's move on. Firing Gina Carano does not. You're not covered because her visual aspect does not ruin the message of the show. Otherwise, you wouldn't have cast her in the first place. I mean, she did a pretty damn good cartoon. I think that's pretty much it. Let's see. Let's see right here. Okay, so I set out in Carano's complaint the defendant's decision to terminate her employment and take additional efforts to destroy her career had nothing to do with artistic storytelling or creative decision or speaker's autonomy. Rather, it was solely for impermissible, discriminatory, and retaliatory reasons, specifically her speech. In doing so, under the allegations in the complaint, defendant targeted Carano but turned a blind eye to her male co-stars on the same topics, thus making her termination impermissible sex discrimination as well. So this is what I wanted to get to. I wanted to read up here to get context. This is precisely why another court in this district rejected arguments similar to those proffered by defendants here. So this is another big thing. Remember how earlier I was talking about how we love Supreme Court precedent. If we can get a Supreme Court precedent that says exactly what we want, it's gold. But we also really like precedent from the circuit that we're in, which is why at the beginning they opened with a Ninth Circuit decision instead of a Supreme Court precedent decision, because they had the actual case that helped them, but it was in the circuit rather than the Supreme Court. I'm not going to talk about Brown v. Board of Education. I'm not going to talk about Plessy v. Ferguson. I'm also not going to talk about that the actual case that Brown v. Board engulfed, the one that we know as Brown v. Board, actually came out of South Carolina and was argued about a mile and a half from where I went to law school. So that was really fun. Nice to know that. Let's see. The court held that not rehiring the plaintiff was not protected under the First Amendment because the alleged reason of the defense decision was the plaintiff's speech and not because of any creative vision of their programs. That's actually big. And this is a recent case too. Rowell v. Sony Pictures. Let's see what this is about. Rowell v. Sony Good old fine law. Let's see. Victoria Rowell appeals the district court's dismissal of her retaliation claims brought under California codes. Let's see. Victoria Rowell is an African-American actress who appeared on CBS's long-running soap opera The Young and the Restless from 1990 to 2007. Wow, that's a long time. Let's see. Beginning in 2005, Rowell sought opportunities for herself to write and direct episodes of Young and the Restless. Appellees, however, denied her request. In 2007, Rowell left Y&R to seek writing opportunities elsewhere, after which she continued advocating for greater minority inclusion in the television industry. Let's see. So Rowell's claim in this is that she was fired because she basically upset the balance. Because it's similar to what what's his name football Kaepernick's claim. It's similar to that they upset the balance and they were fired because of what they did off the field, not on the field. The reason that argument doesn't work for Kaepernick is because he brought the off-field stuff onto the field. So it getting fired or not rehired works in that case because your message directly interferes with the product. In this case, it doesn't because, like I said, she's not walking around Disney Park or standing in the middle of the set yelling whatever they say she yells. The court held that not rehiring the plaintiff was not protected under the First Amendment because the alleged yada, yada, yada. According to the court, the complaint at issue there alleges that the retaliation arose from disagreements with plaintiff and her positions about hiring more African Americans, not ones about the appropriate racial diversity for characters in the programs. For those reasons, based on the present allegation of the complaint, defendants' right to free speech would not be unduly impaired by the relief, if any. That could be granted should plaintiff prevail in the claims. The field was like their domain in the same way the parade was like. Yeah. So their domain, what I mean by that is using the Glib case, which is the Boston parade case I was talking about earlier. The domain there is basically the parade route and what people see on the parade route. Here in Rowell, their domain is the episodes of The Young and Restless. Carano's would be episodes of The Mandalorian. So as long as you don't bring your stuff into the domain and cause the TV show or the I guess in Rowell it's TV show as well. But as long as you don't bring your stuff into the workspace and force Disney or CBS with Rowell to spend money or change things because you're causing issues, then there isn't a problem. So because Gina did not show up on set saying, hey, you know that armor I have? Okay, well, I'm only going to wear armor that has Donald Trump on the side. Or I'm only going to wear armor that says, we will resist, or something like that. Because she didn't do that, Disney doesn't have the right to fire her. That's what Rowell basically claims. Yeah, Maria, that's right. Let's see. I don't really want to go through the rest of this. I have really enjoyed the way they write this. Some of these things, you know, in law school, you read a lot of these, and they can get extremely boring. This one has not been bad. I don't know if, part of it may be that I'm talking to people about it. It is always easier to read these things with people. Sitting in a room by yourself with a book that is that thick with 1,000 of these in them sucks. Let's see. This is the one that I'm kind of more interested in. The First Amendment does not protect defendants' decision to terminate and retaliate against Carano for her protected speech. While defendants further claim they get to determine what message they want to convey, the First Amendment does not give defendants the carte blanche authority to terminate Carano for expressing her personal beliefs. Under the allegations of the complaint, defendants intentionally discriminated and retaliated against Carano for her speech in clear violation of California law. And again, especially at the pledging stage, the First Amendment provides the defendant with no relief here. The fact that television shows are protected speech is irrelevant to the allegations of Carano's complaint. Because again, Disney took what was a pretty well-done complaint, read it, threw it over there, and said, now let's argue this. No, don't look at that. That's not what we're going to argue. We're going to argue what we want to argue. And they addressed like one of the 12 claims that Carano made, which blows my mind. Because again, think about how much money. I mean, when I was doing family law, I wrote a 7-page complaint. And from start to finish, I probably charged $3,000 on that complaint. And that was a 58-page motion to dismiss done by an attorney that was hopefully being paid a lot more than I was charging back then. So it just blows my mind that an attorney would just completely disregard what the complaint actually said. While casting decisions made for artistic reasons are provided some level of First Amendment protection, as noted above, like we talked about with Rowell and stuff like that, termination of cast members is rightly prohibited when done for impermissible purposes. Again, an impermissible purpose would be like what you say in the public forum. Again, defendants claim that, and I'll give you another great example of that is, what was her name? Jane Fonda. Jane Fonda went to Vietnam and famously did that whole tour of Vietnam, came back, and I may paraphrase here, basically called U.S. troops baby killers. And not a damn thing happened to her. Well, let me change that up a little bit. Nothing happened to her in court. She didn't get fired from her job. She didn't lose this or that. She didn't get sued because what she did was not connected to what she was doing as an actress. So they couldn't do anything. But as noted, again, defense claim that in the performing arts, the manner chosen for the performance, including the performers themselves, can be equally or even more crucially to the message being expressed and how the audience receives it. But as noted above, their reliance on Claybrooks, Moore, and Green is misplaced. Under the allegations in Carano's complaint, just as with the press, the First Amendment does not give entertainment producers unlimited discretion to only hire and retain those who only express the organization's values. Again, it's why every 6 or 7 months people talk about the NFL probably getting in trouble for not hiring Kaepernick back, because you're not allowed to just say, well, he says stuff we don't like, we're not going to hire him. If Kaepernick had left everything off the field, maybe if he had kept the clothes, there was that time that he wore the Che Guevara shirt to Miami. He had the socks with cops dressed up as pigs. Maybe you get away with that. But by bringing everything onto the field, you created a thing that interferes with the domain. And if he had been a successful quarterback, yes, he took them to the Super Bowl. But beyond that, he was a middling quarterback. There is far enough reason to believe, to reasonably believe that it is his skills that are not wanting, not his what do you call it? Expressions. Let's go with that. So that's the similar thing here. Felicity says, I always thought the better part of Gina's case was the harassment, but I can definitely appreciate Disney's hypocrisy getting called out. Disney allowed their employees to run wild. So that's another thing. That's one of the reasons why I don't want to see this settle, because I would love to see what Disney says about the harassment that she faced from Lucasfilm. I mean, we've got a little bit of taste of it in the tweets that she released and stuff like that. The amount of hate that was thrown at her and promoted from Lucasfilm employees is ridiculous. I mean, it's actionable alone, in my opinion. Okay, I think I'm going to pivot here, and I think we're going to talk a little bit about what's going on in New York, because I find it intriguing, and I don't really talk about that shit on here. I've been asked about it in the past. I don't really have. 6 years ago, I would have known every single thing. I would have known everyone's name. I would have known exactly what they were talking about, who was voting in what way, everything. But I've just kind of fallen off that. Like, I just don't really give a shit anymore, which is sad. I mean, I know I'm going to vote for it and all that, but I'm intrigued by the amount of people who earned their JD, which is a Juris Doctorate. I'm intrigued by the amount of people that earned that in the last 6 hours. It's incredible. Twitter is full of people who all of a sudden have become attorneys. It's awesome. 100%. 100%. You really could. So let's talk about this. So the first thing we're going to talk about is the New York Penal Code. So once again, I saw a couple of people talking about this on Twitter today. They are in state court. This is not a federal court. This is not a federal hearing. I have the penal number on my phone. Hang on. Or I did. Let's see. So we don't have a verdict yet. What is the thing he's being accused of? What's that first word? Come on, something business records. Falsifying, thank you. Okay, here we go. New York Penal Code 17505. So what we have to do is we have to look at this basically twice. You have to look at first start with, and I'll share this. And real quick, I'm going to oh, that's sweet. Ooh, let's do this. 1 second. Let's do that. Okay. So let me share this. Here we go. So New York Penal Code 175.10. A person is guilty of, this is what he's being charged with. I believe he's being charged with 35 counts of this. A person is guilty of falsifying business records in the first degree. Once again, so he's being charged with this because this is a felony. If he was being charged with it in the second degree, it would be a misdemeanor, and it would have had to have been heard back in 2019. When he commits the crime of falsifying business records in the second degree. So, first thing he's got to do is he's got to commit the previous part of the code. So let's look at the previous part of the code here. A person is guilty of falsifying business records in the second degree when with intent to defraud, he makes or causes a false entry in the business records of an enterprise, or alters, erases, obliterates, deletes, removes, or destroys a true entry in the business records of an enterprise, or omits to make a true entry in the business records of an enterprise in violation of a duty to do so which he knows to be imposed upon him by law or by the nature of his position, or prevents the making of a true entry or causes the omission thereof in the business records of an enterprise. Falsifying business records in the second degree is a Class A misdemeanor. So not only does Trump have to do one of these four things, but he also has to, and when his intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. That's why one of the things you've heard talked a lot about is conspiracies. Because in order to commit a conspiracy, you have to actually be a knowledgeable individual of the conspiracy. And what knowledgeable individual means is you basically have to aid in the conspiracy. If one of the examples we had in law school, and I hope I'm going to get this right, it's going to be embarrassing if I get this wrong, is just because I call up the Sundowners Club and I say, hey, we should rob a bank. Let's rob a bank. And then I go rob a bank. He's not part of the conspiracy. Now, if I call him up and say, hey, March 13th, 2026, there's going to be a truck entering Nashville Savings and Plus. And I've got the masks, I've got the dynamite, I got the code and everything. Let's go. Then, and even then, he's still probably not part of the conspiracy. Then we meet up. He and I drive over there. We sit outside. We watch. Well, he's really becoming part of it now. And by then, he's probably part of the conspiracy. Especially if I go and do the thing. Now, even if he says, nah, I'm out, man. He's still part of the conspiracy because he knows it's going to happen. But if he puts something in between himself and that conspiracy, like calling the police, saying, hey, I know something's going to happen, then you're able to get out of the conspiracy. But that's why the conspiracy thing here is such a big deal, because Trump has to have known more than just, I can't remember who the dude that apparently created the conspiracy is. Who's the guy that apparently paid Stormy Daniels? It's not the general. What's his name? Cohen? So Trump has to have known more than just, oh, he paid her. He has to know more, because that's not, simple knowledge is not part of the conspiratorial triad. Yeah, Cohen. It always reminds me of the Cohen brothers. Anyway, I've got 1,000 notifications, and I imagine one of them is I knew it. Hang on 1 second, guys. Do, 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 do. Okay, where were we? Right, this. So the other thing that's important to do here is, we've had a whole bunch of words. Well, let's go look at the definitions. Enterprise. Well, what's an enterprise? Enterprise means any entity of one or more persons, corporate or otherwise, public or private, engaged in business, commercial, professional, industrial. Holy shit. I have no idea what that word is. Holy shit. Somebody get Jay to pronounce this word. Eleemosynary. I'm not even related to or dependent on charity. Charitable. Never seen that word in my fucking life. Social, political, or governmental activity. Business record means any writing or article, including computer data or a computer program, kept or maintained by an enterprise for the purpose of evidencing or reflecting its condition or activity. So, really fancy way of saying it's basically your fucking ledger. Written instrument means any instrument or article, including computer data or a computer program containing written or printed matter or the equivalent thereof, used for the purpose of reciting, embodying, conveying, or recording information, or constituting a symbol or evidence of value, right, privilege, or identification, which is capable of being used to the advantage or disadvantage of some person. So again, I don't want to see that. Suddenly I've got like 2 bars over here on StreamYards. That was weird. Do I look right, everybody? I'm not like buffering or shit, am I? Okay. So once again, what I'm saying here is that not only does Trump have to have been found guilty of doing one of these 4 things, but he also has to be found guilty of doing it basically in furtherance of another crime. And what a lot of people are kind of hovering around today on is this ruling by Mention, the judge, the activist judge, if ever there was one, to not require a unanimous ruling. Now, I get what people are saying, and this is kind of where my whole lot of people suddenly have law degrees comes from. So a couple things. First, a verdict must be unanimous. This is not going to be some 8 people said he's guilty, 4 people said he's innocent, and he's guilty. It's not happening. A criminal verdict in the state of New York has to be unanimous. That's why there are 18 jurors. There are 12 actual jurors, and then they have 6 reserves in case something happens to at least 6 of the other jurors. So let's look at what Mention said. Mention basically said that actually, let's not do basically. Let's actually pull out what he said. The fuck is that? If that's true, then why did they put a motion asking for a unanimous verdict? I thought the defense that I don't know what that is, but a verdict in the state of New York, a criminal verdict, must be unanimous. It is not only state law, it is constitutional law, both for the state of New York and for federal law. And the Supreme Court actually came out, I forget when. So there are some crimes that you don't need didn't need a unanimous verdict on. And the Supreme Court came out, I think it was last year, and said that those are unconstitutional. That in order to be convicted of a crime, no matter how small, it must be a unanimous verdict. Okay, let's see. I'm getting a bunch of these videos that are these articles that are, who is Judge Merchant? And that's not the article I'm looking for. Okay, here we go. The BBC. All right, here we go. Okay. So let's share this. So there's a little bit to unpack here. There's two things. The first thing I want to get to, so it's 34 counts. Let's see. He spelled out in detail prosecutors' complicated felony case against Mr. Trump. They claim he falsified okay, that's not where it is. Well, I just read it. Here we go. He told the jury that prosecutors do not need to prove these secondary crimes, nor do the jurors need to be in agreement on which specific one Mr. Trump committed. They must reach a unanimous verdict on each of the 34 counts, however. Okay, so there are basically 3 crimes that they are claiming he did 34 times. Here in South Carolina, what the jury charge paper would look like is, and I should have found one. I've got some friends that could have given me one. I should have got one. This would have been great show and tell. But basically what the jury charge paper will say is, here in South Carolina, it would say, did Donald Trump, and we go back to this. Did Donald Trump make or cause a false entry into the business records of an enterprise? Yes or no? Did Donald Trump alter, erase, obliterate, delete? Yeah. Yes or no? Did Donald Trump 3? Did Donald Trump 4? And this would be for all 34 things. If Donald Trump did that, did he do it in furtherance of another crime? And it would probably read, did he do it in... Did he do it to falsify a reimbursement to his fixer for the hush money? Did he do it with the intent to conceal other crimes? Did he do it with violation of state or federal election laws and tax laws? Yes, no, yes, no, yes, no, yeah. Bro, calm it. And we would have 34 of those. What it looks like the charge paper up there is going to look like is actually, technically, we should probably have whatever 34 times 3 is. 90, 102. Up there, it sounds like they're going to have 34. Did Donald Trump do one of these 4 things? It's the 4 for the secondary. If so, did he do it A, B, or C? And they're not going to count A, B, or C as their own yeses or nos. It's just going to be, did he do 1, 2, 3, or 4? If yes, did he do A, B, or C? Or no? No. So they have to answer yes to one of the 4. And then they have to answer yes to one of the 3. But the 3 don't all have to be the same one, is what Minchin is telling them. I can understand why he's saying that. As you read the statute, and like I read it to y'all, when his intent to defraud includes an intent to commit another crime. So it doesn't say, and this is one of the reasons why, again, I'm not a New York attorney. There is probably precedent or what's the word? Procedure, rules of civil procedure for New York that say how juries have to vote in this type of case. If it says that the underlying crime must be agreed to unanimously, then mentions a dumbass and throw him off the bench because he doesn't know how to read a fucking book. If it doesn't, then it's up to the judge's discretion. The judge is God in his courtroom, and he can choose, unless there's prevailing authority to tell him otherwise, he can choose how to interpret the law. Doesn't mean I agree with it. Doesn't mean most people are going to agree with it. Doesn't mean the Supreme Court is going to agree with it. But Felicity, I agree. It is going to be pretty textbook to appeal. They just have to actually appeal correctly. And the reason the appeal is going to be annoying is because the manner in which you have to appeal. So not only do they have to basically constantly say, we object for this, we object for this, but then you have to make sure that you appeal after the fact. And then you have to pray to God that they're going to give you the correct review. So there's 3 ways to be reviewed. There's 3 ways for a judge to be reviewed. I'm so mad that I spent my time on medicine when I should have been a damn lawyer. I'll tell you right now, Felicity. Very few people end up in that room arguing those cases. Most of the time, you're doing what I was critiquing earlier and writing half-assed complaints and half-assed motions to dismiss that you don't even give a shit about. Or you end up like me and you end up caring so much about your clients that you decide, hey, if I just start swerving into traffic, I don't have to worry about these fuckers anymore. Yeah, that's why I do real estate now. I make more money doing that, and I don't give a shit if someone... I'm sorry, your dumbass didn't show up to the closing on time. Not my fault. I love it. Very little of anything that happens, anything wrong that happens at work can actually be my fault now. I love it. Okay, let's get a little bit of a palate cleanser. I'm a little sick and tired of talking about this. I've been talking about this for an hour and a half now. While I get the next thing pulled up, anybody got anything they want to chat about? I did think it was really funny that the Biden campaign held a press conference outside the courthouse, and you could barely hear the press conference because there was such a big rally going on outside. So the funniest thing about this is I'm pretty sure you spelled gynecologist wrong. Let's find out. Damn it. You did. Ooh. Are you licensed? Felicity, you need a new one? Oh, there's a joke in there. Only 10 I see. Where is this thing? I can't find it. Okay, let's go to my bookmarks. So, Matt Smith, lovely Matt Smith, Daemon Targaryen, did an interview. And has anyone noticed that either Variety or them, whoever, interviewed these guys like a month or two ago and have just sat on the entire interview? And it just seems like they release little bits here and there. That's really getting annoying. I would have liked to have read the entire article or entire interview. So Matt Smith was asked about the comparison between House of the Dragon and Game of Thrones. And he said, you're never going to create the moment in time that Game of Thrones was. The love and affection and scale of that show, it's never going to be that because it was a moment in time. And I completely agree. As good as House of the Dragon Season 1 was, and as great as I hope Season 2 is going to be, nothing is ever going to reach those heights of television on Monday morning. Walking into class and going, holy shit, did you see that? I can't believe he fucking died. Like, we're never going to get that. We're going to get we're going to rise to that level where you call your buddy, you go, dude, that was really great. Or we spend 3 hours talking about it on YouTube, or we make YouTube videos about it. But it's never going to rise to the level of an event that Game of Thrones was. Similarly, Jesus Christ, movies are never going to rise to the level that Lord of the Rings was. We are never going to see another movie made with the care and attention to detail that we saw in Lord of the Rings. It's never going to happen. And in my opinion, this is a new opinion for me, I think to expect that is to expect failure. I think if you judge every movie by Lord of the Rings, that you are just psyching yourself up for defeat. There are other yardsticks to use, other movies to measure other cinema by. When there are people that claim Citizen Kane is the greatest movie of all time. You don't see those people say, well, it wasn't as good as Citizen Kane. Because it can't be. How can a movie that comes out in 2024 be as good as the greatest movie of all time? A fantasy movie that comes out today can never be as good as Lord of the Rings was. But it can strive for it. And the best way of doing that is to make sure that the people involved give a shit. And not give a shit about progressing the message or forcing a story down someone's throat, but telling the actual story. And what's so funny about that is our good friend George R. R. Martin said something very similar today, or 5 days ago, actually. Where was it? Here we go. A few years back, Neil Gaiman, great. And I did a joint event in New York City where we were both in town. It was a lot of fun, as events with Neil always are. We told some funny stories, talked about books, comics about Sandman, Wild Cards. Oh, yeah, the story that he's still writing instead of giving us the fucking book that we're waiting for. That's what Wild Cards is, if you weren't sure. And touch on some serious topics, too. I would like to upload a video of the event if I could. Yeah, but Variety had the best report of the session. Okay, so What the fuck is this? Hang on, where was this? Oh, this is an old ass article. I got excited there for a second. I thought we got another art book. Let's see. If you don't like spoilers, don't read the whole book. Buy it. Here we go. On honoring source material. As someone who has been on both sides of screen adaptations of literature, Martin discussed the obligation to be faithful to the written material, which he said is a controversial issue in Hollywood. The author made it clear where he stands. How faithful do you have to be? Some people don't feel that they have to be faithful at all. There's this phrase that goes around, I'm going to make it my own. I hate that phrase. And I think Neil possibly hates that phrase too. I do, Gaiman responded. I spent 30 years watching people make Sandman their own. And some of those people hadn't even read Sandman. To make it their own, they just flipped through a few comics or something. Gaiman added that it was a joy getting to make season 1 of The Sandman on Netflix. And Martin apparently gathered up some energy to say he wants season 2. Once again, write the fucking book, George. Martin continued, there are changes that have to be there are changes that you have to make or that you're called upon to make that I think are legitimate. And there are ones that are not legitimate. He recalled adapting Roger Zelazny's The Last Defender of Camelot for an episode of The Twilight Zone. And due to budget constraints, being forced to choose between having horses or an elaborate Stonehenge-esque set for a battle scene. He didn't want to make the decision, so he called up Zelensky, who chose to scrap the horses. That, to my mind, is the kind of stuff that you were called upon to do in Hollywood that is legitimate. An example of an illegitimate change, Martin said, was CBS making him include an ordinary person who just tags along in the episode to appeal to a high concept. I was new to Hollywood. I didn't know I was new to Hollywood, Martin said. I didn't know you're fucking morons. I'm just going to save that. That may be my new favorite quote from George R. R. Martin. Love that. Martin related the topic to the Iron Throne and HBO's adaptation of his Song of Ice and Fire novels. Why is the Iron Throne in Game of Thrones not the Iron Throne described in the books? Why is it not 15 high and made of 10,000 swords? Because the ceiling in our soundstage was not 15 feet high. We could have fit it in there, and they weren't willing to give us St. Paul's Cathedral or Westminster Abbey to shoot our little show in. So I'm not going to go through all this. Hang on Winds of Winter. For those hoping for an update on the oft-delayed 6 Ice and Fire book, Martin offered no definitive timeline. I claim to live for 1,000 years, he said, before I got to finish Winds of Winter. More just wait and see shit. All right, so let's go back to that was all back in 2022, but very little has changed since then. If anything, things have gotten worse, and this is where he really gets into them. Everywhere you look, there are more screenwriters and more producers eager to take great stories and make them their own. It does not seem to matter whether the source material was written by Stan Lee, Charles Dickens, Ian Fleming, Roald Dahl, Ursula K. Le Guin, J.R.R. Tolkien, Mark Twain, Raymond Chandler. Is it Raymond Chandler, like a porn writer? Jane Austen, or, well, anyone. Hang on. Why do I know that name? What did he write? No. I don't know. I could have sworn. Oh, well. Doesn't matter. No matter how major a writer it is, no matter how great the book, there always seems to be someone on hand who thinks he can do better, eager to take the story and improve on it. The book is the book. The film is the film, they will tell you, as if they were saying something profound. Then they make their story their own. They never make it better, though. 999 times out of 1,000, they make it worse. Once in a while, though, we get a really good adaptation of a really good book, and when that happens, it deserves applause. Like Lord of the Rings. Peter Jackson changed things. He moved things around. He made the timeline more clear. He removed a lot of stuff. He removed Tom Bombadil. He removed the Scouring of the Shire. He removed the end for Legolas and Gimli. He removed the end for Aragorn. He removed the end for Arwen. He removed the end for Faramir and Eowyn. He removed the end for basically everyone except Frodo. Because at the end of the day, The Lord of the Rings is a story about Frodo. It has 1,000 endings, and only one of them are about Frodo. So if you're going to make a movie and decide that the base of the story that you want to tell is Frodo Baggins' story, then you can't tell all 999 endings. You have to just choose one. And Peter Jackson chose Frodo's ending to tell. This is terrible English. I came across one of those instances recently when I binged the new FX series of Shogun, which I do need to watch. Must confess I was. This is a little hypocrisy on Martin's part because he dealt with D&D. He wanted the money, so whose fault is it that it went badly? So I agree with you, Felicity. I think this is complete hypocrisy. But if we're going to allow ourselves to change our minds about things, I think we have to understand that other people change their minds. I think the same thing when it comes to a politician that, says something differently today than they did in 1999. We see a lot of instances, especially recently, of this person said this in 1999. Now they're saying this. Well, it's been 20 years. It's been 25 years since 1999. They might have changed their mind. So to just assume, and I'm not saying you're doing this, to just assume that they've held the same position for the last 25 years, I think is idiotic. In this case, I think it's reasonable to say that George probably changed his mind after dealing with D&D, after dealing with HBO and the destruction of the story that he wanted to tell, especially because we know that the non-inclusion of Lady Stoneheart was such a big problem for him. That's why he wrote her back into the story. He wanted Cat to stay alive. He changed his mind and he wrote Lady Stoneheart so he could bring Cat back alive. And I think D&D's choice to just completely scrap that really pissed him off. And I think that can be seen through just the complete change in not only story but in enjoyment of the show. I think I finished what I was saying there. Okay, I think I'm done there, guys. I promise I will put out a video sometime this week. I don't know why I haven't done it. I've got 2 or 3 recorded. I just haven't edited them because. Hang on. What did you say, Felicity? It's not that I don't agree with what he's saying, but it needs context. And if this is how he feels, what does that say about all those adaptations he has in the works with HBO? So, in my opinion, what it says is I will never cede control, because my understanding is that he stepped away from HBO, from Game of Thrones. Season 5 was, I believe, the last one he had really any sort of control over. And he said after D&D basically completely said no to Lady Stoneheart, he was like, you know what, fine, fuck you, I'm out. And we've seen with Ryan Condal and now Madison, what's his name? Matthew Madison? What is his name? What's the Sundowners? Where are you, buddy? Mattson Tomlin. So we've seen with Mattson Tomlin and Ryan Condal that he seems to really have much more of a foothold in what they're putting on screen and have much more control. Because, we saw the article the other day that Tomlin went and basically had dinner with, I almost said Tolkien, with Martin to talk about where he was in the book, how far he was in the, what's it called? The script that he's writing for Aegon. I think that does go to show that George has tried to maintain a level of control that he gave up on in Game of Thrones. So yeah, I think that's now. I think our best guess of that is going to be with what do you call it? Not the Seven Kingdoms. I think that's when we're really going to know whether or not he actually gives a shit. But yeah, that's me, guys. That's all I got to say. I went a little bit longer than I thought I would. I hope everyone has a great night. Hope you'll have a great weekend. I know tomorrow's Thursday, but we're getting there. End of hump day. And again, everyone, thank you so much for being here. Talk to y'all later.